Good morning, Ms. Rose. We're already streaming and recording.
Okay.
Good morning, everyone.
Good morning, Judge.
Good morning, everyone. Nice to see you.
Good morning.
You see, we're already streaming on YouTube, so I will keep that in mind.
Okay. Good morning, Judge.
Morning, Chief. How are you?
Well, thank you. All right. I think we're ready. I'm gonna go. Oh, we got a couple of minutes. We're already streaming on. We're already live streaming. I'm going to go ahead and admit the lawyers. And you're going to announce court, Rose, right?
Yes, ma'am.
Thank you. Rose, do you remember how the time was going to be allotted? I've forgotten already.
For the appellees, 8 minutes for the appellee Vulcan and 12 minutes for Texas Commission.
And for Vulcan Construction, again, I'm sorry.
8 minutes for appellee Vulcan and 12 minutes for Texas Commission.
Okay.
Good morning, Council.
Good morning, everybody.
Morning.
Welcome. For those of y'all who have not participated in oral arguments virtually, you should be able to see up in the screen the time remaining. And so my understanding is the appellant, obviously, Mr. Irvine, is going to have the 20 minutes, and then Mr. Courtney is going to do 8 minutes. Ms. Snoddy is going to do 12 minutes. Is that correct? And then Mr. Irvine, you have 10 minutes for rebuttal.
Your Honor, I think that Ms. Snoddy is going to go first, and then I, for Vulcan, will go second with the 8 minutes, if that's okay.
Yeah, that's no problem, just so that
Okay, thank you.
we have that understanding. All right. So with that, I will have Rose, if you can announce court for us, please.
Sure. The Court of Appeals for the 8th District of Texas is now in session.
Thank you. And at this time, we're going to commence with oral argument in case number 08-20-00035-CV. Judge Ferguson and Judge Palafox accompany me on this particular panel. And I would like y'all to know, we always say this, but just to clarify, we have had an opportunity, obviously, to review the briefs, to discuss that with the court staff. And so we are familiar with the facts, if that aids in your presentation this morning. And with that, you may proceed, Mr. Irvine. Thank you.
It just sent me to mute. Can you hear me?
Yes.
Chief Justice Rodriguez, may it please the court. I'm here on behalf of a coalition of local residents and parents at a local school very close to a facility that is sought a permit from TCEQ to build a concrete batch plant. With environmental cases, these are complicated statutory schemes, so I apologize if we get into the weeds on some of the statutes. But I think it's always important to get a little bit of context for your honors on, the actual situation and what's going on. We have here a statutory scheme under the Texas Clean Air Act, which has two statutory provisions that are our issue. One is a statutory provision which we call a mandate because it contains the word shall, that says TCEQ shall consider the impact of these air emissions on a school if the school is within 3,000 feet of the facility boundary. The second statutory provision is one that issued through a legislative act this particular type of permit that the applicant here seeks. So that's kind of the tension we're looking at here. A little bit of background, we covered it briefly in the briefing, and the context is that the original application here was for a regular concrete batch plant permit application. And in that permit application, it allows for people who are affected persons under TCEQ rules to request a contested case hearing, which is a trial-like proceeding where people who are affected can challenge the permit application and TCEQ's decision to issue the permit. That original application would have allowed a contested case, which one of the issues would have been, is this permit protective of the school, the high school, Hill Country Montessori School, which is within, I think it's undisputed in the record, is within that 3,000 foot distance. So that would have been one of the issues under the original permit application. After a lot of public interest and a lot of comments, that's why the administrative record is so exceedingly large in this case, and we apologize for that. But a lot of over 4,000 public comments were received on that application. 400 public comments were received on that application. The applicant withdrew that type of permit, which is the standard concrete batch plant, and pivoted to this concrete batch plant permit with enhanced controls. And that is a legislative creature created by, by the Texas legislature that was intended to provide a streamlined method by which this particular type of plant could be permitted in exchange for not having to go through a contested case hearing. So here the applicant avoided going through the contested case hearing there was still a public meeting on the application where comments are taken, and that was the decision that TCEQ made. And our issue that we are presenting on the appeal here is whether or not, when the applicant applied for that concrete batch plant permit with enhanced controls, TCEQ erred when it decided it did not need to do a school protectiveness review. There are some disputes between TCEQ and us about whether such a review was done, and TCEQ takes a number of positions in its brief that you'll have seen. Either it can't do a protectiveness review of schools, or it did do a protectiveness review of schools, or a protectiveness review would be, futile and duplicative. So that's their sort of various positions. The school, it's undisputed, is within 2,000 feet or approximately of the concrete batch plant. This is not a unique issue. We have seen a number of concrete batch plants apply for this type of permit more recently. So this is not a one-time issue. Whether or not TCEQ has to review for school protectiveness is going to arise again and again. And we have a dispute initially over what is the standard of review for this particular type of appeal. We would argue under the Texas Clean Air Act 382.032A, the standard of review is invalid, arbitrary, or unreasonable. TCEQ argues that the standard of review may include those, but also may include a substantial evidence standard of review, which under administrative law concepts is highly deferential to the agency. I think we briefed that, and the court will decide, which standard of review is applicable here. I think we prevail under either standard of review, but we remind you that substantial evidence review is tailored for situations where the parties in dispute have gone through a full contested case, through a trial-like proceeding, where evidence is tested, it's disputed, there's contrary evidence submitted, and then the fact finder, whether it's an administrative law judge or the TCEQ commissioners, can then weigh that disputed evidence. And so that's kind of ideally tailored for substantial evidence review. Here we just have a decision by the agency without any contested case. And so, we do think that although we would concede that this particular area of law, administrative law in particular, is less than clear. There are cases that go substantial evidence encompasses everything. There are cases that say no, under the Texas Clean Air Act, it's invalid, arbitrary, or unreasonable. And so that's kind of like the first dispute we have there with TCEQ. We have briefed one issue in this case, whether or not this particular permit decision by TCEQ did review the protectiveness of the application with respect to the high school, the Hill Country Montessori School. Little context here. Schools are the home of particularly sensitive small people. These children range in the high school and Hill Country Montessori range from 2 to 14 years old. Part of the curriculum there, being in the Hill Country, is they spend a lot of time playing outdoors. There's a lot of green space around where that school is. So this is why the parents there were particularly concerned about this particular concrete batch plant. The legislature, in passing the school protectiveness requirement, which simply says TCEQ has to consider the protectiveness when a school is within 3,000 feet. It doesn't say you have to deny it, just says you have to consider it. And the reason is that the health impacts are recognized to be more significant on young children, particularly very young children. They are sensitive receptors. And so the Texas legislature, in its wisdom, decided you have to do a little more when it comes to school kids that are near a source of air emissions and odor and air contaminants. So that's what we say the law requires. That's 382.032. Sorry, yes, 382.032 of the Texas Health and Safety Code. I'll call this the school consideration mandate. We briefed this, and it says in the statute that TCEQ shall consider. That's a, obligatory term. There's no discretion there. TCEQ must consider whether the permit application is protective for a school when that school is within the distance requirement. Now, along comes the legislature later in time after passing that school protectiveness requirement and passed the specific legislative permit type at issue here, which is a concrete batch plant with enhanced controls. So the legislature came in and said, here is a type of permit that TCEQ shall issue. There is a different type of permit that TCEQ, the standard concrete batch plant permit, which is different altogether. But TCEQ must look at these 19 factors. That's in 382.05198. And then the procedural requirements are in 05199. And so we look at those 19 requirements that an applicant must meet in order to get a concrete batch plant permit with enhanced controls. And when I say that an applicant, this is really just a registration, okay? The permit has already been issued and it exists. And what an applicant does is they fill out basically a checkbox application saying, we will comply with all of these permit terms in the enhanced control permit. TCEQ's position initially is that, and they took this in their response to comments when issuing the original permit, is that TCEQ lacks jurisdiction to consider schools within 3,000 feet under this type of permit. In their response to comments, that was their position initially. TCEQ in its briefing, both below and here, has taken a more nuanced position and argues that those 19 factors passed by the legislature are exclusive factors, and that anything that lies outside of those 19 factors that the legislature listed cannot be considered by TCEQ. I did not see in their briefing that it actually deprives TCEQ of jurisdiction to consider it, but I think that's the effect of their argument, is that when legislature came in later and listed 19 factors, that's all that they consider. As you know, those 19 factors, there is one factor which does identify a provision listing schools, and that's a distance prohibition. And that's one of the important differences between this type of enhanced control permit and a normal concrete batch plant permit, in that 440 yards from the facility is a prohibition on any residence or school. So that's one of the increased protective factors that the legislature wrote into this type of permit. But when they wrote that in, they didn't simultaneously say, and this provision, this prohibition substitutes and pushes away the actual consideration of protectiveness for schools within 3,000 feet. So that standalone mandate continues to exist, and we argue continues to apply to every single permit that TCEQ issues. It's not limited in any way. The legislature could have come in when they passed the enhanced control statute provision and said, oh, and by the way, this provision supplants the school protectiveness review in 382.052. It didn't do that. But that's effectively what TCEQ is now arguing to the court, is they can ignore that provision and they don't have to do it. That's one of their first arguments. We briefed on the issue of whether the 19 factors are exclusive and therefore push away any other consideration outside of those 19 factors. Obviously, one of the things that we urged was that TCEQ itself goes beyond those 19 factors. They do a compliance history review. The compliance history review is also required, or it's allowed by the Texas Clean Air Act, but it's not mandatory. TCEQ can decide whether or not to do it. It uses a may provision. TCEQ may review compliance history of an applicant when deciding whether to issue an application. So here we have 19 factors in the statute for the enhanced control permit, And we have TCEQ applying and incorporating in the decision for this permit a 20th factor that is not mandatory. They, in their discretion, decide to apply it anyway. So here we have the TCEQ saying we don't have to look at the mandatory factor of school protectiveness, but we will look at this allowable consideration of compliance history for this particular applicant. And that, to me, it doesn't make sense, right? You know, if a statute says shall, you don't push that out, but then still apply the statutory provision that says you may look at compliance history. TCEQ, in its brief at page 28, argues that the concrete batch plant permit with enhanced controls actually prohibits any kind of additional consideration of schools. It cites their appendix tab 5 saying, look at the concrete batch plant with enhanced control permit. I think it's footnote, one of the footnotes there at the bottom of page 28. And they say, an applicant is prohibited from including any additional information about schools within 3,000 feet when they apply for this permit. I looked through what they cited to, which is the actual concrete batch plant with enhanced control permit document. And I couldn't find any prohibition from the applicant, including in their application, additional modeling for school protectiveness. It just says it's not required. Additional air dispersion modeling is not required. It doesn't say it's prohibited. So I'm struggling to understand TCEQ's argument there. Whether or not TCEQ lacks the jurisdiction to consider the school protectiveness review, we would say no, it doesn't. The legislature knows how to deprive TCEQ of jurisdiction. It effectively did that when they issued the concrete batch plant with enhanced controls, because they were getting a lot of contested applications where people were discussing noise and traffic, things that are plainly outside of TCEQ's jurisdiction. But here we still have this school protectiveness requirement left in the statute when the enhanced control permit was issued. So, you know, the lawmakers know how to deprive TCEQ of jurisdiction, and they did not do that here. This permit scheme, I admit, I mean, I do a lot of environmental law, and I know some judges love it and some judges hate the sort of complexity of the regulatory environmental scheme. It is a complex scheme that TCEQ oversees here. And sometimes—
Mr. Irvine, if I may stop you for a minute, excuse me. So the thing that I'm struggling with, and so maybe you can help me with, is how do we define consider? How do we apply that term?
Your Honor, I would say consideration means there has to be something in the record which suggests that TCEQ conducted a substantive review. It doesn't mandate a particular outcome. It doesn't mandate a denial of the permit. It just says you have to consider. And what we have in the response to comments is TCEQ saying we're not going to consider it because we don't have jurisdiction to consider it.
But that was their position initially. So now that we're at this posture, what are you, I guess, what is your primary argument in that they didn't consider, consider it?
And I get your question, Your Honor, and I will try and answer it. I think the argument is that the record doesn't reflect any kind of consideration here.
Any kind of consideration, like zero.
There is in the record, and TCEQ does brief this, an argument that when they issued the concrete batch plant with enhanced controls, they somehow relied on an earlier assessment and review of school protectiveness for the standard concrete batch plant permit.
Right.
I think TCEQ has to concede that they did not specifically do a school protectiveness air dispersion modeling for this type of permit. So this type of facility, as best we can tell from this record has never had an actual TCQ review, i.e. consideration of the school protectiveness requirement. And, you know, the scheme is complicated, and we concede that occasionally things fall through the gaps. Just last week, TCQ denied a standard concrete batch plant permit because they had forgotten to incorporate a silica requirement when they reissued the permit. And they actually had to deny and concede that there was a gap in this regulatory scheme. So it's complicated, and we know it's complicated, and TCQ, I'm sure, will tell you how complicated it is, but at heart, we're looking for an actual review here.
Mr. Irvine, just from a practical perspective, what would a school protectiveness review look like? Is it site specific, or can you give us a sense of when it is conducted? What does it look like?
So there are two types, Justice, of review that I would envision. One would be a generic air dispersion modeling where the TCQ would take this type of facility with these controls and conduct their generic air dispersion modeling to look at whether a school within 3,000 feet, you know, has any kind of issue with air quality. The other type of review could come from the applicant, where they do a site-specific air dispersion modeling that incorporates the local weather conditions and the terrain and this specific site and this specific school within 2,000 feet. So there are two different ways that this consideration or review could play out, and neither of those exist in this record. And, you know, I'm sure the applicant will explain that they weren't required to do air dispersion modeling, in which case maybe TCQ should have done it. We would ask that the court remand this back to the agency to fix this gap if it agrees with the coalition that there is a regulatory gap in the scheme. It is, we think, easily fixable. I see my time is up, so I will finish there. Thank you.
Thank you very much. And now, I believe, Council Ms. Snowdy.
May it please the court. The TCEQ was not required to conduct a school protectiveness review specifically for Vulcan's application in this case, because the TCEQ already conducted such a protectiveness review when it issued the standard permit with enhanced controls. And that review applies, because this is a standard permit, it applies by incorporation to any application under that permit. This review ensures that all facilities operating under the standard permit will be protective of children attending nearby schools, and additional site-specific analysis would be directly contrary to the legislature's intent in creating the standard permit. The TCEQ's interpretation of the statute that the school requirement was satisfied by this original protectiveness review is the only interpretation that can harmonize the statutory sections at issue and give effect to each section. Accordingly, this court should affirm the TCEQ's approval of Vulcan's application to operate under the standard permit. Before I get into talking about the statute, I just want to touch briefly on the standard of review. There's no real dispute here over the standard of review. We agree that the standard under the Clean Air Act is whether the decision was invalid, arbitrary, or unreasonable. The Third Court of Appeals has interpreted this as incorporating the scope of review set forth in the Administrative Procedure Act, which is known as a substantial evidence standard, that entire scope. One basis for reversal under the substantial evidence standard is whether the decision was arbitrary and capricious or characterized by an abuse of discretion, which the coalition has invoked in this case. This case also involves a question of statutory interpretation. Questions of statutory interpretation are reviewed de novo, but an agency's interpretation, longstanding interpretation of a statute that it administers is entitled to some deference. The court should uphold the agency's interpretation as long as it's reasonable and in harmony with the statute. So there's three sections of the Clean Air Act that we're asking the court to interpret here today. There's two sections that make up the standard permit for concrete batch plants with enhanced controls. Section 05198, which lists those 19 requirements for the standard permit, and then Section 05199, which outlines the procedures to apply for authorization to operate under the standard permit. in which directs the TCEQ to base its decision whether to approve or deny the application on whether the application meets those 19 factors listed in 05198. And then there's also the separate school protectiveness statute that requires the TCEQ, when issuing an air quality permit, to consider schools located within 3,000 feet. While Mr. Irvine has pointed out that 052, the school protectiveness section, does in fact create or use the word shall, we also must note that 05199 also says the ED shall base its decision on whether to issue the permit on whether or not the application meets those 19 factors listed in 05198. So we have two mandates here. We have the mandate in the school protectiveness review, but we also have that mandate in section 05199H, which says the ED shall base its decision on whether the application meets those factors. So it seems that there is a little bit of a conflicting mandate. And so the question before the court is, how do we harmonize those two requirements? How do we harmonize the mandate to only base its decision on whether the permit meets those factors with this mandate to also consider schools?
Ms. Snowdy, I want to jump in. I have a quick question. Circle back to the definition of consider that we heard from Mr. Irvine. Do you agree with their position that to consider that issue, the school issue, it requires a formal review of that specific plant, and so therefore the prior one would not satisfy? Is that required for someone to consider the issue satisfactorily under the statutory scheme?
We do not agree with the coalition's interpretation of that term consider. Our interpretation is that the TCEQ, when issuing the standard permit, did consider schools because it conducted a protectiveness review that envisioned protectiveness at the fence line of the property, and therefore would necessarily encompass any school within 3,000 feet. So the term consider here just means that the TCEQ was required to take into account, to consider protectiveness at schools that may be located near a facility. Because this is a standard permit, all of the controls are set by statute, and any facility that's operating under those controls is going to have similar emissions. And so what the TCEQ did is it conducted a protectiveness review based on the national ambient air quality standards set by the EPA. It ran air dispersion modeling for the specific controls of the regular standard permit. We're dealing with the enhanced controls, which are even tighter, so we can expect greater protectiveness from this permit. And what it did is it determined that the emissions from any facility operating under these specific controls is not going to exceed those NAAQS, the National Ambient Air Quality Standards, which are set at concentration levels that are determined to be protective of human health and welfare, specifically for sensitive subgroups, including children. So they determined that any facility operating under this permit will be protective at the property line and therefore would be protective of any school within 3,000 feet. And so that's how the TCEQ considered the schools for the standard permit, because the standard permit is different from a case-by-case permit where you're considering the actual schools that are located near the facility, in that anyone can operate under the standard permit if they meet the controls listed in statute. And so the TCEQ's way of harmonizing these two statutes is to consider the protectiveness of schools when it did the original protectiveness review, and determined that any facility would be protective of the NAAQS at the property line.
And that leads to the hypothetical that I wanted to pose. And I assume Mr. Irvine will be listening, and I'd love to get his response when he takes the podium once again. In the scenario you just described, where they had done one on a plant that you're saying would be not as well controlled as the one that they are now pursuing on the permit. If in that meeting on the enhanced, someone said, well, I read the report they did before, and I don't think, having read that report, we need to do another full review because that one was for a plant that's not quite as protective as this one. And if that one was okay, we should be fine here too. So that's my consideration of the impact on the school. Does that satisfy the requirement under the statute to consider the impact on the schools within 3,000 feet?
Yes, that satisfies the requirement to consider the schools. It's the TCEQ in establishing its protectiveness review for this enhanced control standard permit did base its review on that air modeling that it conducted for the regular standard permit, which found that the emissions would be 99.9% compliant with the NAAQS at 100 feet from the central baghouse. And now we have enhanced controls, they're even greater than that. So the TCEQ looked at that air modeling and said, okay, we know that 100 feet from the baghouse, we're going to be compliant with the NAAQS and protective of human health and welfare, including children. And so we know for sure that these enhanced controls that we've added are also going to be protective of schools. And there, as Mr. Irvine mentioned, there's even a setback distance, which is an additional control of 440 yards from schools. So the TCEQ did consider within the meaning of 052 the protectiveness of schools within within 3,000 feet of any facility operating under these specific controls.
Thank you.
So again, we have this conflict in statutes, or what appears to be a conflict in statutes. And the way that the TCEQ has harmonized those statutes and the two mandates in those statutes is that it reads the consideration requirement, as we just discussed, as requiring it to consider, when issuing the standard permit, the protectiveness of the permit for schools. And that will apply to any facility operating under these controls. Because it's a standard permit, we know that if they meet these requirements, they will be protective at the fence line. And then that gets incorporated into any application under that standard permit. And this is reflected in the ED's response to comments when the public raised concerns about the proximity of the Hill Country Montessori School. In their comments, the ED specifically pointed to this NAAQS review that was conducted for the regular standard permit as to demonstrate that the concrete batch plant enhanced control permit would be protective of children at that school. So it's done, the work is done once, but then it kind of by incorporation applies to all of these applications because they're all operating under the same controls. We're not altering the controls. The protectiveness review was done at the worst case scenario parameters, continuous operation. So we know that any facility operating under these controls of this permit are going to be protective. And that's how the TCEQ has harmonized the statutes in this case. Mr. Irvine brought up the compliance history review as a factor that the TCEQ might consider. I just want to point out the compliance history review is not mandatory, and it doesn't add any substantive requirements that an applicant must show to be entitled to the permit. If under BBCCE's interpretation of the statute, they would be required to do air modeling, which is a substantive consideration outside of those 19 factors, which would, again, alter that mandate that the TCEQ only consider those 19 factors. Compliance history is an internal review that the TCEQ conducts. It doesn't put an additional burden on the applicant to make a showing. It's not mandatory, it's voluntary. And so we don't believe that that adds an additional consideration under 05198. So the TCEQ's interpretation of the statute is the only way to harmonize the standard permit statute with the requirements to consider schools under 052. BBCCE's interpretation creates a conflict within the statute and is directly contrary to the legislature's intent in creating a standard permit. Because the Clean Air Act didn't require the TCEQ to conduct a site-specific protectiveness review just for Vulcan's application, this court should affirm the TCEQ's decision to approve Vulcan's application to operate under the standard permit. Yeah.
All right, thank you, Mr. Courtney. I can't hear you. Okay. There you go.
May it please the court. The issue in appellant's brief is whether TCEQ is required to conduct what I'm going to call the 382.052 consideration, the consideration we've been talking about for Vulcan's application specifically, And I will explain that the answer to that issue is no. And why, even if it wasn't no, it would still have been impossible for TCEQ to have conducted the 382.052 consideration for Vulcan's application. But even if you were to disagree, you should still affirm TCEQ's approval of Vulcan's application, because it would be redundant for TCEQ to conduct the 382.052 consideration for Vulcan's application, because, as Ms. Snowdy discussed, TCEQ had conducted the protectiveness review for the standard permit, which showed that anybody off-site, including any children at the school, would be protected. That protectiveness review is discussed in much detail in both TCEQ's and Vulcan's brief. Neither 382.052 nor 382.05198, which established the standard permit, required TCEQ to conduct the 382.052 consideration for Vulcan's application. First, the language of 382.052 supports that conclusion. That language clearly states that 382.052 consideration only applies when TCEQ is, quote, considering the issuance of a permit. And so when we talked earlier about this shall mandate, the shall mandate is conditional to if TCEQ is considering the issuance of a permit. TCEQ's decision to approve Vulcan's application to authorize use of the standard permit did not involve TCEQ considering the issuance of a permit, because the decision did not involve in issuing a permit to Vulcan in response to the application. Indeed, TCEQ's decision could not have involved it issuing that permit to Vulcan in response to its application, because TCEQ had already issued that permit back in 2004. Instead, TCEQ's decision involved it approving Vulcan's application to authorize use of that standard permit, because the application shows compliance with the requirements in the permit. That is consistent with the language in 382.05199 subsection A and subsection H, which collectively state that if TCEQ determines an application to authorize use of the standard permit meets the requirements, TCEQ shall, quote, approve, close quote, that application. That language properly does not say TCEQ shall issue, because, as I mentioned, the permit was issued back in 2004. And so since TCEQ's approval of Vulcan's application did not involve considering the issuance of a permit to Vulcan, the 382.052 consideration was not required for Vulcan's application. That conclusion is further supported by a comparison of TCEQ's rules regarding applications for standard permits and for case-by-case air permits. When TCEQ considers whether an application for a case-by-case air permit complies with the applicable requirements, TCEQ is considering the issuance of a permit, because if TCEQ determines that the application shows compliance with the requirements, it will issue that permit to the applicant. Based on that, it's not surprising that TCEQ's rules require that case-by-case permit applications include the 382.052 consideration. In contrast, when TCEQ considers an application to authorize use of the standard permit, it is not considering issuance of a permit, because, as I mentioned, that permit's already been issued. It's considering whether to approve the application because it shows compliance with the conditions of the permit. The TCEQ rules reflect that difference by not requiring standard permit applications include the 382.052 consideration. Second, the language of 382.05198 and 382.05199 also demonstrate TCEQ was not required to conduct the 382.052 consideration for Vulcan's application. The language of 382.05198 shows it is exclusive in the sense that there are 19 requirements in it that must be met for TCEQ to approve an application for that standard permit. Subsection A of that section specifically lists those 19 requirements that TCEQ is required to include in the standard permit. And subsection H of 382.05199 specifically requires that TCEQ base its decision whether to approve an application for the standard permit on whether the application meets the 19 requirements. Critically, none of those 19 requirements relates to the 382.052 consideration. Since 382.052 predated 382.05198, and since case law states that the legislature is presumed to know about statutes that exist when it enacts a new statutory provision, the fact that 382.052 consideration is not one of the 19 requirements in 382.05198 demonstrates the legislature's intent that such consideration not be included for such standard permits. And that intent is supported by one of the 19 requirements that has been mentioned that specifically is aimed at protecting school children. And that's the 440-yard requirement that says that a company cannot use the standard permit if the plant will be closer than 440 yards. And so that's in spite of the fact that 382.052 included the 3,000 feet, the legislature put in the 440 yards requirement. For these reasons, TCEQ was not required to conduct the 382.052 consideration for Vulcan's application. Notwithstanding that, it would have been impossible for TCEQ to have done so. Such consideration would necessarily have required Vulcan to conduct air dispersion modeling and the TCEQ to review that modeling. But those activities, as well as the other activities that TCEQ is required to conduct under 382.05199, could not have been completed in the short time frame of 5 months that's allowed under the statute for TCEQ to evaluate Vulcan's application and either approve or deny it. TCEQ clearly understood that impossibility as reflected by its inclusion of condition 1, capital D, in the standard permit, which states that an application for a permit is not required to include modeling. It had been mentioned by Mr. Irvine that even though that's not prohibited, that modeling is not prohibited, it would be impossible due to these timeframe considerations. In conclusion, not only was TCEQ not required to conduct the 382.052 consideration, and not only would it have been impossible for TCEQ to have done so, it would have been redundant for TCEQ to have done so, and it would be redundant for this court to require TCEQ to do so. And that's because, as Ms. Snowdy described, TCEQ conducted a protectiveness review for this standard permit that was based on the protectiveness review for the less protective standard permit, the regular standard permit. And that showed that everybody, including every child located off-site, including every child at the school of concern, would be protected by this standard permit if their conditions are met.
Mr. Courtney, it sounds like you just agreed with Mr. Irvine that to consider that issue, they would have to do full formal modeling and review with TCEQ. Is that what your position is necessary for consideration under the statute?
No, Your Honor.
Well, then why are you arguing it's impossible for them to consider if it's not required that they do the modeling to have consideration?
Right. What I was saying is impossible for them to consider it relative to Vulcan's application because of the short timeframes that's set forth in the statute for TCEQ to make a determination. But it would be redundant. In addition to being impossible, it would be redundant. It's not necessary for TCEQ to have required or considered the 382.052 consideration for Vulcan's application because it considered it for all applications that will for the standard permit when it conducted that protectiveness review. So the purpose of that protectiveness review, as Ms. Snowdy said, it protects every person from every concrete batch plant that meets those requirements in the standard permit, because the modeling that TCEQ conducted and compared to the National Laboratory Air Quality Standards, that was very conservative analysis that was conducted for that standard permit, since every standard permit is going to have the same emissions from that concrete batch plant that meets the requirement. So the protectiveness was ensured. The consideration occurred whenever TCEQ did that protectiveness review. It didn't need to occur for Vulcan's application. In addition, it couldn't have occurred. And as we shared, the statute doesn't support it needing to occur for Vulcan's application. But it was the children will be protected because of the protectiveness review that TCEQ conducted for the standard permit itself.
Thank you. Rebuttal, Mr. Irvine?
Yes, Your Honors, thank you. So we had a number of issues raised there. I heard some agreement and some disagreement. On the first thing that Mr. Courtney was talking about, the 440-yard prohibition that exists in the concrete batch plant with enhanced control statute, that's a blunt tool, right? That prohibition simply says you cannot have a residence, you cannot have a multifamily residence, single family residence, or school or place of worship within that distance and still be in compliance with the permit. It doesn't do anything in terms of applying a discrete review for these particularly sensitive school children. And so I would say that's a blunt tool and really doesn't satisfy this requirement for a particular review for schools that the statute elsewhere requires. I mean, the description of the permit is essentially correct. It's a registration. It's a checkbox application. Okay, and we don't want to get too much in the weeds, but the checkbox application is essentially the same for a standard concrete batch plant permit and a concrete batch plant permit with enhanced controls. There is a checkbox there saying, is it within 3,000 feet of a school? Okay, so what you have here, if TCEQ's interpretation is correct, is the possibility that there is at least some consideration when an applicant applies for a standard concrete batch plant permit, but then no consideration of schools when an applicant applies for the enhanced control permit, which would kind of create this perverse incentive where if you're an applicant and you identify a site for your normal concrete batch plant and you encounter opposition and you realize there's a school within, I mean, the school in this case was within 2,000 feet, which is barely outside that 440 yards. 440 yards is about 1,300 feet. The applicant simply then ditches the standard permit application and switches to the one with enhanced controls. And enhanced controls can be a little misleading. The reason why these concrete batch plants have become such a hot topic in the state is because, you know, they are being located next to homes, next to schools, next to churches, and people are receiving impacts, okay? Concrete batch plants are not always run in complete compliance. So people are very fearful when TCEQ says this is protective, but then, you know, the plant runs and there's dust and there's complaints, and then they're reliant on TCEQ's enforcement, which I will say is sometimes a little variable. So this is a hot topic. And what we don't want to encourage is this perverse incentive that this particular type of permit allows an applicant to evade any kind of school protectiveness review. The issue of whether there was any actual consideration of protectiveness for schools when the TCEQ issued the enhanced control permit. TCEQ in Appendix Tab 5 has a copy of the August 2004 air quality standard permit for concrete batch plants with enhanced controls. And they cite to page 7 of that document to say there was a protectiveness review. And what that says is the comprehensive air dispersion modeling completed previously for the air quality standard permit for concrete batch plants protectiveness review will be used to demonstrate state and federal standards are not exceeded. There is nothing in, and it's one paragraph, right? And they simply incorporate, they say, we did it before, we're not going to do it again for this type of facility. And I don't think TCEQ will dispute that. Their argument that I hear is that, well, because it's enhanced controls, it's got to be more protective and more conservative. But I'm not actually hearing that there was any actual review for this type of facility, which does have some differences from the regular facility. I would say this issue is still live. The facility has not yet been constructed, to the best of my knowledge. So it's not, you know, oh, they're already operating and we haven't seen any impacts. My clients tell me that actually the site was put up for sale recently. So we don't know whether this permit will actually ever be done, but it's not under construction right now. And there may be a mootness issue that arises, but we'll see about that. Our position just generally is there has to be some review for schools built into this permit. And we're not seeing it in TCEQ's record. We're not seeing it in the application from the applicant. The applicant could have done something more here. There's no prohibition against the applicant doing some sort of demonstration, whether it be through air quality modeling, which can be done in 5 months. There's no technical reason why you can't conduct air quality modeling review in that time. And there's no prohibition against the applicant making some demonstration that we are not going to, you know, send plumes of dust over the school. we are protective. We've looked at this and show to the community that they, you know, while not prohibited from putting such information in front of TCEQ, if the applicant puts that information in front of TCEQ, then TCEQ can review it. And that would have satisfied the term consider the impact on those schools within that 3,000-foot distance. So we would once again argue that this permit can be remanded back to TCEQ for them to either conduct the first type of review, which would be the more detailed high-level review for the permit itself, or for the applicant to submit some scintilla of information as part of their application package to demonstrate that air quality for these sensitive school children will not be impaired by the operation of this facility. Unless there are questions, I'm happy to rest there.
I do have a question, Mr. Irvine. Are you saying it would be redundant? Well, how do you respond to the argument that they say it would be redundant because this modeling has already been incorporated in this application process?
And that is a very good question, Your Honor. That, you know, while we haven't, and part of this record does not show exactly what was modeled for the standard concrete batch plant air dispersion modeling, we do concede that there was at least a full air review model done for that type of permit. Our argument here is it wasn't done for this type of permit, which does have some characteristic differences. I agree that if the court finds that, you know, anytime something is more protective, that's just enough. I would argue that the statute requires a little more than that. The statute for, you know, 382.052 requires an actual consideration, and saying we did it before, so we're not going to do it again doesn't seem to me to be actual consideration of this type of facility.
Thank you.
Any further questions? Yeah. All right. Thank you so much for your superb presentation, Council, this morning. We appreciate it. You've made our jobs more difficult. So thank you so much again. We appreciate y'all doing this virtually for us, because I think hopefully it's helpful to you. It's extremely helpful to us. So with that, your case will be submitted based on the briefs and the excellent argument this morning.
Thank you for your hospitality.